So my goal tonight is to use these recently decided cases to help you point towards some of the aspects, the direction the court is taking, and to help you read the newspapers in a more informed way when the court decides those significant issues in its current term. But before we start, I think we need to review the cast of characters in this little drama that is playing out in Washington. We have a court of 9 justices, 3 of whom are firmly on the liberal side. That's Justices Kagan, Sotomayor, and the newest justice, Justice Jackson. The 6 conservative justices are Chief Justice Roberts, Justices Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. But of those 6, 3 of them, the Chief Justice and Justices Kavanaugh and Barrett, are considered the ones most likely in specific cases to vote with the liberal wing. Now, don't over understand this. They can't be called centrists or swing votes because they are definitely solidly conservative. I think of it this way. When a lawyer arguing a liberal issue before the court, that lawyer is trying to persuade 1 or 2 of those, well, he needs to persuade 2 or 3 of those 3. So let's first start by looking at 7 cases the court decided during its last term. So the first 3 are all 6-3 decisions that were decided along ideological lines. And they involve free speech and gay marriage, affirmative action, and forgiveness of student debt. So the first case, 303 Creative versus Elenis, involved a website designer who did not want to make websites for same-sex marriages, claiming that it would violate her First Amendment right to freedom of speech. It's interesting to note that Colorado, where she lived, had not taken any action to challenge the position of the web designer. So basically the court took the case even though it was sort of a hypothetical case because she hadn't suffered any particular injury. Nevertheless, in an opinion written by Justice Gorsuch, the court ruled in her favor 6-3, holding that her First Amendment right to free speech would be violated if she were forced to create a website for a same-sex wedding. Now, Justice Sotomayor dissented, pointing out that this issue involves commercial businesses, an area where other laws such as equal accommodations may be in conflict with this First Amendment principle. So she really raised questions about the scope of the decision. And indeed, I find it difficult to find a limiting principle in the case. It's important to note that the issue was freedom of speech, not freedom of religion. So the big remaining question is whether this decision opens the door for freedom of speech arguments in other contexts, such as race or gender. I suggest that the future will bring more litigation testing whether the court will expand the principle beyond assertions based on opposition to same-sex marriage. The second case, actually 2 cases, the affirmative action cases. Now they involved a public institution, the University of North Carolina on one hand, and a private institution that received federal funding, Harvard University. And in a 6-3 decision written by Chief Justice Roberts, the court adopted a race-blind approach to the Constitution and struck down any use of race in admissions. Now, the court specifically stated that its ruling doesn't prevent an applicant or a student discussing in an application how race may have affected them personally. But the court made it clear that the admissions policy, when considering such a statement, must base the decision on factors such as the student's determination and courage in overcoming adversity. I see two issues that remain to be determined in this area. The first is that the decision specifically does not apply to the military academies. Now, the suggestion is that because the academies are designed to create leaders capable of leading our armed forces, that their mission is uniquely distinct from that of the institutions that were covered by the decision. However, on September 19th, a lawsuit was filed against the United States Military Academy at West Point, claiming that the decision should be extended to them and the other military academies. So that likely will wend its way through the courts and could come up to the court in a few years. And then the second issue I think is interesting is legacy admissions. Legacy admissions have been challenged in a number of schools. Some schools are eliminating them, and I think there will also be litigation about that. So stepping back to the case at hand, we seem to have a court that has two distinct views about the Constitution and race. So the 6-member majority views the Constitution as prohibiting government from drawing lines based on race. But the 3-member liberal minority sees the 14th Amendment as requiring equal protection of the law, and they make a big distinction between policies of exclusion and policies of inclusion. Now, for the student debt forgiveness case, to understand this decision, we need to actually go back to a case the court decided in 2022. It's called West Virginia versus the Environmental Protection Agency. And you may recall this case because in it, the court significantly limited the extent to which the Environmental Protection Agency could regulate greenhouse gases. And in that decision, the court invoked, at that time, a novel theory called the Major Questions Doctrine. And this doctrine requires that regulatory agencies must identify in their authorizing legislation passed by Congress a clear congressional statement supporting their decisions if they have a substantial political and economic impact. So in the student debt forgiveness case, which was a 6-3 decision written by Chief Justice Roberts, the court ruled that the Major Questions Doctrine, they used the Major Questions Doctrine to strike down the Biden administration's student loan forgiveness program, saying that the legislation that created the program didn't give the Secretary of Education the authority to establish a forgiveness program. So, 3 6-3 decisions along ideological lines. Okay, now let's turn to some of the surprises from last year. 4 unexpected wins for the left, if you will. The first one involves voting rights and racial gerrymandering. It's called Allen v. Milligan. It came out of Alabama. And it was a 5-4 decision written by Chief Justice Roberts, in which the court held that Section 2 of the Voting Rights Act can be used to address situations of extreme racial gerrymandering. And the Chief Justice and Justice Kavanaugh joined the 3 liberals to form the majority. And in the decision, they rejected Alabama's argument that the court should focus on the maps that Alabama created, which they said were computer generated and did not take race into account. Well, the opinion reasoned that this would be inconsistent with the Voting Rights Act requirement that courts under the Voting Rights Act, look at all of the relevant circumstances. And they cited a relevant 1986 Supreme Court decision in support of that. So as a result, they concluded that Alabama should have not one, but 2 congressional districts that are majority black. Now, similar litigation is proceeding. Some of it was put on hold pending the outcome of this case. Now it's going forward. There are 32 active Section 2 cases in 10 other states, 10 or 12 states. So it remains to be seen whether these other cases will be resolved in time to have an impact on the 2024 congressional elections. But I note that for a while after the decision, the situation in Alabama didn't seem to be resolved at all. The legislature, immediately after the decision, prepared a new map, again with only one majority district. And in early September, a 3-judge panel struck down that map. And on September 11th, Alabama asked the Supreme Court to put that panel's decision on hold pending an appeal. And on September 26th, the court said no. And on October 5th, a 3-judge panel ordered a map for Alabama that contained 2 majority black congressional districts. Well, one of the commentators I read called this deja vu all over again. It certainly seemed that way. It really seemed as if the Alabama legislature wanted no part in creating a map that would comply with the Supreme Court's decision. Well, it's been resolved in that the Alabama official responsible for elections has announced that the map dictated by the 3-judge panel will be used for the 2024 election, but also indicated that the state plans to continue to litigate the issue. Second case is also a gerrymandering case, but this involved partisan gerrymandering as opposed to racial gerrymandering. It's a North Carolina case called Moore v. Harper. And in this case, the claimants asserted the independent state legislature theory. And this theory contends that the Constitution gives state legislatures the unfettered right to regulate federal elections, unfettered by state or federal courts. Well, in a 6-3 decision, the opinion again by Chief Justice Roberts, who was joined by Justices Kavanaugh and Barrett and the 3 liberals, the court rejected that independent state legislature theory, noting that state courts traditionally have been viewed as having the right to invalidate state laws that are inconsistent with the state constitution, and holding that there are no exceptions to that tradition for laws relating to elections. Then the third case in this my list of 4 is involved the Indian Child Welfare Act, and is called Halen versus Brackeen. Now, this act was legislation that was passed by Congress in 1978 in reaction to a long history of separating Native American children from their families. Now, the law sets minimum standards for removal of Native American children and establishes a preference that children who are removed be placed with extended family members or in Native American foster homes. Writing for the majority, Justice Barrett's opinion rejected all challenges to the act, holding it constitutional. And that was a 7-2 decision, with all but Justices Alito and Thomas in the majority. And then the 4th case is an immigration enforcement case. It's called U.S. v. Texas. And it involved a challenge to the Biden administration's policy of prioritizing 3 groups for apprehension and deportation: suspected terrorists, non-citizens who've committed crimes, and non-citizens caught recently at the border. Well, Texas and Louisiana challenged the policy on the basis that these priorities were too narrow because the federal law requires the government to detain and deport certain non-citizens who aren't covered by the order. Well, rather than address the substantive claims, in an 8-1 decision, the opinion written by Justice Kavanaugh, the court held that states do not have the legal right to bring this lawsuit. The concept is called standing. So the court noted that there's no precedent authorizing states to order the executive branch to change its policies so that it makes more arrests or pursues more prosecutions. And Justice Alito dissented from that decision. So here we have 3 6-3 decisions: free speech and same-sex marriage, affirmative action, and student debt forgiveness, alongside 4 decisions in which some of the conservative justices joined the liberals, and those were extreme racial gerrymandering, partisan gerrymandering, and the independent state legislature theory, the Indian Child Welfare Act, and immigration enforcement. So it looks sort of like a tale of 2 different courts. Keep in mind that that 6-member conservative majority could have made 6-3 decisions in all 7 cases, but they chose not to do so. It's interesting to note what was predicted a year ago at the beginning of the 2022-23 term. Based on the court's performance in the preceding term, it was widely expected that the conservative majority would continue its challenge of long-standing precedents, and that Chief Justice Roberts would remain a figurehead with little power over the court. So what's going on, and what does it tell us about the court? Well, the first thing I saw after the end of the term was that Adam Liptak of the New York Times published an article in which he looked at recent public opinion polls on various issues, and he found that in all 7 of these cases, the decision was in line with public opinion. Now that's really different from the situation in the abortion decision overturning Roe v. Wade in the preceding term. So it might suggest that perhaps some of the justices have taken note of the court's persistent declining approval rating. It's currently down to 40% from almost 60% in 2020. And so perhaps they've pulled back to a more incrementalist approach. Second thing I'd like to point out is that it seems that the predictions of Chief Justice Roberts' loss of control of his court were premature, perhaps. I note that in November 2022, the Washington Post published an opinion piece by Ruth Marcus titled "The Tragedy of John Roberts." Now, in the term that just ended, he was in the majority in divided cases 86% of the time. I think that was more than any other justice. And he was the author of many of the most important decisions, such as affirmative action, student debt forgiveness, Alabama racial gerrymandering, and North Carolina racial gerrymandering. Another thing I'd like to point out is that among the 56 decisions handed down by the court during that last term, which I note is the lowest number since the 1860s, which is kind of startling. But among those 56 decisions, there were significantly more unanimous opinions and fewer cases decided 5-4 or 6-3 along ideological lines as compared to the earlier term. So it's impossible to determine whether this might be attributable to more effective leadership by Chief Justice Roberts or other justices' sensitivity to negative public perception of the court, or maybe some other factors that might be at play. And finally, I have to point out that it's dangerous to make sweeping assertions or predictions on the basis of one term. But what I can say with some confidence is that the 2022 to 23 term of the court was a very different story from the one that preceded it. So let's turn now to the term that began on October 2nd. The court now has 42 cases on its docket. And I expect it will add maybe 20 or 25 more as the term progresses. But keep in mind that the court receives thousands of petitions. So these cases that have made it to the court's docket are among the select few. And here are some significant issues. I think I have 8 or 9 on my list here that the court will address. Number one is gun control. Now, during the 2021 to 22 term, the court significantly reduced states' ability to control guns, holding that the Constitution provides a right to carry a gun outside the home, and stating that we have to look at take an originalist approach and look at the traditions and understanding of gun control at the time that the Constitution was enacted. Well, the two cases now before the court raise two questions. And the first one is whether a state may impose gun controls on individuals who are subject to domestic violence restraining orders. That's called U.S. v. Rahimi, and the oral argument took place on November 7th. And the second case raises the question whether a restriction on the sale of bump stocks is constitutional. The case is Garland v. Cargill. And I note that there's a conflict in the circuits on this issue. The Fifth and Sixth Circuit held the prohibition invalid, but the DC Circuit and the 10th Circuit upheld the restriction. Now, when there's a conflict between the circuits, the Supreme Court is almost certainly going to take that case in order to resolve the conflict. Actually, there are, in a sense, 4 cases before the court. Number 2, this case raises the question whether the bankruptcy code authorizes a court to approve, as part of a plan of reorganization, a release that extinguishes claims held by non-debtors against non-debtor third parties without the claimant's consent. I'm sorry, that's a real mouthful. Let's try to unpack that a bit. I think you'll get the idea when I tell you that the name of the case is Harrington versus Purdue Pharma. So Purdue Pharma is a company controlled by the Sackler family, and it filed for bankruptcy in 2019, seeking protection from lawsuits claiming it was a major cause of the opioid epidemic through its deceptive marketing of OxyContin. So the Sackler family put in $4.5 billion to fund a proposed reorganization plan. A key element of the settlement is that individual members of the Sackler family also would be released from liability, although technically they're not parties to the bankruptcy proceeding. So the bankruptcy court approved this settlement, noting that it was the only way that they could see to provide funding for communities to address the opioid problem. The Justice Department, however, is appealing the approval of the plan, claiming that the bankruptcy plan creates a backdoor that allows the wealthy and powerful to evade liability for wrongdoing without having to declare bankruptcy themselves. That case will be argued on December 4th. Number 3, in 1984, the court ruled in a case called Chevron v. National Resources Defense Council that courts should defer to a federal agency's interpretation of an ambiguous statute as long as that interpretation is reasonable. Well, since then, it's been a goal of the conservative movement to challenge this rule. And the current cases, there are two of them, Loper Bright Enterprises v. Raimondo and Relentless versus the Department of Commerce, involve a challenge to a rule issued by the National Maritime Fisheries Service that requires the fishing industry to pay for the cost of observers who monitor their compliance with fishery management plans. So this case really reflects a contest between the executive branch and the judiciary as to who should interpret ambiguous statutes. And I think that this might be a case where the court's majority again invokes that major questions doctrine that I mentioned earlier. Number 4, the court will consider another voting rights case, this one involving a claim of racial gerrymandering in the South Carolina congressional redistricting plan affecting 3 of the state's 7 congressional districts. It's called Alexander v. South Carolina Conference of the NAACP, and it was argued on October 11th. Number 5, 2 cases involving social media use by public officials are also before the court, and they raise the question whether a public official engages in state action subject to the First Amendment when blocking an individual from the official's social media account. The first case involves members of a school board in Southern California, and the Ninth Circuit found a violation of the First Amendment. And the second case involves the city manager of Port Huron, Michigan, and the Sixth Circuit found no such violation. So here again, we've got a conflict in the circuits, and that's one of the main reasons that the court took this case, I'm sure. And the oral argument took place on October 31st. Number 6, conservative groups have long sought to limit the powers of the Consumer Financial Protection Bureau. And the Bureau was formed in response to the 2008 financial crisis. And this case is called CFPB versus Community Financial Services Association of America. Involves a claim that the Bureau's funding scheme, which operates outside the normal congressional appropriations process and involves funding directly from the Federal Reserve, that violates the Constitution's appropriations clause, which says, quote, "No money shall be drawn from the Treasury but in consequence of appropriations made by law," end quote. I note that the challengers in this case involve payday lenders. That case was argued on October 3rd. Number 7, more than 30 federal administrative agencies, including the Securities and Exchange Commission, use administrative law judges to adjudicate certain matters. The Fifth Circuit held in the case of the SEC that this violates the 7th Amendment's guarantee of a jury trial, as well as other provisions of the Constitution. So this case is called Securities and Exchange Commission versus JARCA-C, and it will be argued on November 29th. Number 8, on September 29th, the court added 2 cases to its docket, raising the issue of the constitutionality of Texas and Florida laws regulating how social media companies control content posted on their websites. This is also a situation where the circuit courts are divided because the Fifth Circuit upheld the Texas statute and the 11th Circuit held the Florida statute unconstitutional. And those have not been scheduled for oral argument yet. And then number 9 is technically not yet on the Supreme Court's docket, but I think it's likely that the court will hear an appeal from the Fifth Circuit involving the case of the abortion pill. So early this year, a Texas judge issued a decision preventing the use of the drug and issuing a nationwide injunction against its sale and use. Now, the Supreme Court subsequently granted a stay of enforcement of the decision pending an appeal. And the Fifth Circuit held on August 16th that the sale and use of the drug should remain legal, but with significant restrictions on patients' access to it. The Department of Justice is appealing that Fifth Circuit decision to the Supreme Court, asking that the Food and Drug Administration approved dispensing standards be reinstated. So that's my 9 topics before the court this year. But before we close, I'd like to cover 2 important topics involving the court. And I think our timing is good, so.
Yeah, very good topic.
The first is the shadow docket. Now, the shadow docket the shadow docket is kind of a pejorative term for the emergency docket that the court uses. I recently read a book by Professor Stephen Vladeck of the University of Texas Law School titled The Shadow Docket. And here's a quote from Professor Vladeck. The bottom line is that most of what the court does is behind the scenes, shrouded in obscurity, driven by norms far more than by rules, and informed by the specter of deeply strategic behavior from all sides to which the public is generally not privy, end quote. I think we could agree he's not a fan of the court or the shadow docket. But the term shadow docket refers to those orders that the court issues in matters where there has been limited briefing and no oral arguments. And it serves an important role in managing the court's business. But recently, and especially during the time when the court was operating remotely during COVID, the court relied on the shadow docket to issue substantive rulings. And these rulings may not be, may not be attribution. In other words, they don't tell which justices supported the ruling. And they don't have to explain the basis for the ruling. So one consequence of this is that lower courts are sometimes confused about the extent to which these decisions constitute precedent that they are required or expected to follow. Well, during this past term, the court seemed to use the shadow docket less than in previous years. And I think this might reflect a bit of a course correction, or it simply could be an aberration. But I can assure you that court watchers will continue to pay attention to whether the shadow docket is being used to further ideological purposes. And finally, we have to talk about the important ethics issue. Can't avoid it. This issue has been in the news during the last year more than any other Supreme Court case, with the possible exception of the abortion decision overturning Roe v. Wade. Well, following watchdog organization revelations of gifts and perks and travel and other questionable behavior on the part of practically every justice, but especially focused on Justice Thomas, there's been a huge cry for more ethics standards on the court. Now, legislation has been introduced in Congress requiring that the justices adhere to a code of conduct, but since it doesn't have bipartisan support, it's not going anywhere. The Senate Judiciary Committee they have been investigating the Supreme Court ethics issues, and they invited Chief Justice Roberts to come and testify on the issue, and the Chief Justice declined to accept the invitation. But he sent a letter to the committee chair attaching a statement of ethics principles and practices, which the letter states are subscribed to by all of the current justices. Another thing that's happened is disclosure statements. On August 31st, Justices Thomas and Alito filed their extended filing of their disclosure statements for 2022. And their disclosures included items that they didn't disclose in earlier years. Some of them were of the type that was called out by the watchdogs. So it seems that maybe some of the members of the court may be paying attention to the calls for ethics reform and are doing what they can do to head it off. I believe that we all would agree that we would I think we could all agree, we deserve to have a court composed of justices who are above reproach from an ethics standpoint. I'm seeing a lot of heads nodding. Let me point out 2 reasons why this is not as easily accomplished as we might wish. First point, in the case of federal district and circuit court judges, all of whom are subject to a code of ethics, when they have a conflict and need to recuse themselves, in other words, they can't participate in a case, there's a clearly understood mechanism for substituting another judge. Well, with the Supreme Court justices, there are no other comparable justices. So recusals leave the court at less than full strength and raise the possibility of a deadlock, a 4-4 decision, for example. So the Chief Justice's letter to the Senate Judiciary Committee states, quote, "Justices have a duty to sit that precludes withdrawal from a case as a matter of convenience or simply to avoid controversy," end quote. So that duty to sit is something that he's emphasizing. Second point is, in the case of all the other federal judges, ethics challenges are overseen by other federal court judges, but not judges from the same district or circuit. So they're not daily in working together. But in the case of the justices, it's difficult to see how that would work because there are no other comparable judges and the Supreme Court justices work closely together at all times. And in this regard, the Chief Justice's letter states, quote, "If the full court or any subset of the court were to review the recusal decisions of individual justices, it would create an undesirable situation in which the court could affect the outcome of a case by selecting who among its members may participate," end quote. And indeed, there is no other group, not lower court judges and certainly not Supreme Court employees, who can comfortably or easily sit on judgment of an ethics issue on the court. Well, fast forward to today, and much to my surprise, the Supreme Court today issued a statement of the court regarding the code of conduct, and they have promulgated a code of conduct. Now it's about 8 pages long, and then there's another 6 or 8 pages of commentary on it, and I've read it through once quickly. And I think I can say that the main thing in here is there's no enforcement process. So it leaves the court in the position that we've just been talking about, and that is that each justice makes his or her own decisions about the propriety of what they do in terms of serving on the court in a particular case. I've read it really briefly, and I note that there's a statement about restrictions on acceptance of gifts and the prohibition on solicitation of gifts. And there's apparently a judicial conference regulation on gifts now in effect, and this says that they should comply with that. I haven't had a chance to read that to see how that might apply to private airplane, all that stuff. Another thing that's
Yeah.
interesting is, one of the things that I think it was Justice Sotomayor was criticized for was that she used court staff to assist her in, you might say, marketing a book that she had written. And there's a statement here that a justice should not, to any substantial degree, use judicial chambers, resources, or staff to engage in activities that do not materially support official functions or other activities permitted under these canons. And earlier, they talk about how justices may receive compensation from publishing books and so forth. So I think that may resolve that issue in favor of Justice Sotomayor's practice. So that's just a little quick preview. I'm sure that there'll be some much more intelligent commentary coming out in the next couple of days that we'll all be looking at with interest. So just in closing, let me say that I think it remains to be seen whether we'll continue to see more robust disclosure, financial disclosure by the justices. And even if it continues, I have my doubts about whether it will have the effect of reducing the criticism of justices who accept lavish entertainment and other financial gifts from wealthy individuals who are perceived as having an agenda for the court. So I hope you found this quick tour through the past and the present helpful and interesting, and we've got some time for questions. So, yes.
I don't have or have ever had a handle on the shadow docket. And I understand you said we can't see it, but what result or consequence could you describe so that I could see some results of how it works?
So you can actually see it on the Supreme Court's website. It's called the emergency docket. And so they will list orders that the court has issued. So, for example, whenever there's a federal execution, capital punishment, you can expect that that will be appealed to the Supreme Court. And usually they handle those decisions by issuing an order saying that either the execution must be delayed or it will not be delayed. And so it's just a statement, maybe one sentence, naming the case and stating the decision of the court. So again, these are items that do not, there's papers that are submitted because they make an application to the court, but there's no oral argument in the case. So does that help understand this a bit more?
A little bit.
Yeah, I think that one of the more abrupt changes that happened after Justice Ginsburg died and Justice Barrett went on the court was that the shadow docket rulings involving the question of churches' compliance with local requirements regulating gatherings during COVID, the court shifted to more favorably rule in favor of the churches. And that was perceived as more of a political, ideological reflection on the court, which many people felt was inappropriate for the shadow docket because there was no reasoning behind the change in the courts, the outcome of the rulings. And this professor has written 350-page book. Other questions? Yes.
On the 4 cases where the three conservative judges voted the other way, was there some kind of a unifying aspect of those cases that made it clear to you why they switched on those cases compared to the cases where it was 63?
I don't have one. I can't, maybe I should repeat, the question was on, in the 4 that I mentioned that were wins for the liberal side, the question was there a unifying theme among them that made me understand why they had voted the way they have? And I really can't say that I have a good theory for that. The cases, I think none of the cases were on a list of the wish list of the conservative movement. But although the independent state legislature theory was a conservative brainchild. Yes.
You may have said this, but how is it determined what cases they're going to take in the
How is
current
it-
session? Who determines how
Okay.
is it determined?
So once a case has been decided by a circuit court, the parties can apply to the Supreme Court, and as I said, they get about 6,000 or 7,000 applications a year. So it takes 4 justices to decide to take a case.
Okay.
Now, that doesn't mean that the 4 agree on how it should be decided. They may actually have different views on how this, but they think it's an important enough case that the court should address the issue.
So that means that they're reading all many thousands?
So-
Or someone is reading?
Not all applications are read by all of the justices.
Right. Okay.
My guess is that some of them aren't read by any of the justices, but no, I think that each circuit has one justice that's responsible for them. So there's kind of a sifting process that the clerks and the justice that are responsible for a particular circuit then kind of say, well, here's some more we want to take to the full court to see if others agree that this is an important question to go before the court. So they will put it on a list, and I think this is published, a list of cases that they're going to decide during a conference on a particular day. And sometimes they'll issue orders after the conference that says declined or ordered to be put on the docket or carried forward. They call that relisting for another conference. So you can keep track of the cases, the applications by number that way. It's a big complicated process. Okay. How about court reform? Well, let me just say that I do not favor adding judges to the court. Although actually that one statistic that I gave you about not as many, the fewest number since 1860, maybe they need a few more justices to carry the workload. But I don't like the idea of trying to rejigger the ideological divide by adding justices for that purpose. I think that's a dog chasing its tail and you end up with a big court that's unwieldy. I do favor term limits. And the big issue there is the light concept of life tenure and what that means. Some would argue that it means that they just have to be paid the same whether they're doing the job or not. So my idea would be to, once they've satisfied the term that they're given, they then would go into like a senior status, be paid the same, have the same privileges and perquisites. I mean, they could play on the basketball court and so on. And then, if my interpretation is correct, that could be accomplished without a constitutional amendment, which would be. Okay. Oh, question.
You know, I'm just thinking about the situation where a judge chooses to recuse themselves, and one of the things he said was they're urged not to do that, and one of the reasons they're urged not to do that is because it puts the burden on 8 instead of 9, and it could be a split decision. Well, I understand the burden, and that might be relieved by your suggestion. But the other part, so what if the Supreme Court disagrees? In a sense, if it's a tie, in a sense, stare decisis, or however you say it, the previous decision to stand. So that is a decision.
Yes, that's true. So it's a decision in the case in particular.
Yeah.
But wouldn't it serve as precedent for the other courts? So it makes it doesn't let the court function in the way that the court is supposed to, which is not just deciding individual cases, but telling us how to apply the law to other cases. And that's what we want the court to do. We don't want them to just be deciding these narrow cases. So,
That was good.
okay. Thank you all very much. You've been terrific.